Today on Ramblings with Rebecca, the last look at the principles of the European Court of Human Rights, margin of appreciation. The margin of appreciation refers to another main way in which the European Court of Human Rights decides in its judgments whether or not a state has breached its obligations under the European Convention of Human Rights. This, along with the European Consensus that we talked about earlier, is kind of the two main principles that the court uses. This margin of appreciation doctrine allows the court to take into account factors that influence how a state is going to interpret the convention, recognizing that cultural, historic, philosophical differences between member states and between the court in Strasbourg and the states themselves are going to appear. People interpret things differently. And it often makes sense for states to carry out and implement laws that are well situated in its own context. This margin of appreciation is trying to get at allowing for that. It was used for the first time in a case on handicide versus the United Kingdom, good old UK, looking particularly at a book aimed at school children, one chapter of which discussed sexual behavior in rather explicit terms. You get up to all sorts of fun things in Strasbourg. The book was published with pretty much no problem in many other signatory states of the European Convention system. But the court decided that it was going to allow a limitation of the freedom of expression in the interests of the protection of public morals, or whatever you want to call it, at that time. Question, debate, right? Surely if it's allowed in one state, it should be allowed in the other state. That's the whole point of regional systems? Yes, no? On the other hand, part of the point of having regional human rights systems, along with the global human rights system, is allow for those regional systems to zoom in on the particular context of the region. Same kind of rationale here is allowing states to really zoom in and understand and take into account everything that's going on in their particular system and interpret the convention, in the light of those. This margin of appreciation business is an English translation of the French phrase marge d'appréciation, which I'm sure that I'm saying horrifically, I'm sorry. This concept is used in a number of courts in Europe, so this was not something that's unique or created by the European Court of Human Rights. But also the European Court in Luxembourg uses it. It refers to the range of discretion. It's allowing leeway for states to get at this. This, of course, is highly related to European consensus, but is going... you could say surely it's the opposite of, right? Like, instead of looking across what all of the states are saying, it's allowing one state to say a specific thing. But it's related in that it's trying to get at allowing states to set, standards for themselves and just making sure that those standards are fair and actually happening. This is another, also, it's similar to the European consensus, is that it's another mechanism that allows the state to continue having the authority that it does. Using this margin of appreciation allows the court to keep states in the system and make sure that they don't tick off folks too much, and then lose any authority that they do have. This doesn't mean that it's all encompassing or all allowing. There certainly have been times when a state has come to the court, argued margin of appreciation. No, we're just, interpreting this in the way that makes sense for us. And the court said, poo, yeah, right. Nice try. That's too far. But this line is not solidly set in stone, and it is, depending on the issue and what's going on. This, of course, is the whole reason that we have courts, to help interpret these issues and to apply these things when there isn't a clear black and white obvious decision. Much as perhaps the law does want to pretend it's black and white. Nice try. Excuse me. So these two concepts come up in a lot of case law. There's a lot of essays written around them, whether or not they are good things independently together. Whether they limit or help the European Court, that kind of thing. I tend to think both of them are fairly good things. It's a good thing to pay attention to local context, and it's a good thing to enact measures that are going to actually have things be implemented. Feel free to disagree. Please disagree. Tell me what you disagree about, and I will put some links at the bottom for further reading on both of these.